Good morning. I call this hearing to order. I want to welcome our witnesses. We appreciate your participation and look forward to your testimony today. Under the healthcare reform law and its final rule, insurers must spend 80% of premium dollars for individual and small group policies on health claims. This medical loss ratio means the amount that can be spent on administrative expenses is limited to 20%. If an insurer fails to meet the minimum requirements, it must issue rebates for differences for the difference to its customers. Insurance agent commissions are counted as administrative cost under HHS under the HHS rule. The agents, often small business owners themselves, assess the unique health insurance needs of small firms, recommend appropriate coverage, and help to process claims. In several letters to the Department of Health and Human Services, the National Association of Insurance Commissioners, or NAIC, the Organization of State Insurance Commissioners, which HHS entrusted with recommending the MLR formula, expressed concern about the adverse effects of the MLR on insurance producers, both agents and brokers. On November 27th of this year, NAIC endorsed 26-0, a formal resolution urging HHS to, quote-unquote, take whatever immediate actions are available to the Department to mitigate the adverse effects the MLR rule is having on the ability of insurance producers to serve the demands and needs of customers and to more appropriately classify producer compensation in the final rule, unquote. Unfortunately, HHS did not include NAIC's recommendations in its rule, and agent and broker compensation remains a part of the administrative calculation. We want quality health care and affordable insurance premiums, but the MLR is likely to deter small insurers from entering the market and hasten the exit of established ones. Instead of protecting consumers, the MLR may dissuade insurers from making investments in anti-fraud, anti-waste, customer service, and transparency tools because they are considered administrative, and those costs must be kept low. The MLR is an incentive for insurers to increase, not reduce premiums, because they will need to improve their medical ratio and forgo administrative tools that can ultimately save money. And as NAIC's resolution said, the MLR requirements, quote, have had profound detrimental marketplace effects for insurance producers, agents and brokers, unquote. In a recent study on implementation of the new MLRs, the U.S. Government Accountability Office said that, quote, almost all of the insurers, unquote, it interviewed had decreased or planned to decrease commissions to brokers or reduce their MLRs so they can avoid issuing rebates. The National Association of Health Underwriters reports that nearly 3/4 of agents have experienced reductions in their income because of MLRs, and more than 1/5 have eliminated jobs at their agencies. Clearly, federal medical loss ratios are a bad idea for small business. I look forward to hearing from our witnesses today. I now yield to the ranking member for opening remarks. Mr. Schrader.
Thank you, Mr. Chairman. I appreciate holding this hearing today. While I'm not so sure that the medical loss ratio is altogether in itself a bad piece of policy, I am concerned about its effect on our agents and our brokers. That was never our intent, I don't think, in passing the medical loss ratio. We're looking for feedback to see if the ratios that were instituted in the Affordable Care Act are actually real. And I think it's very, very important to have this hearing because the agents for small businesses are absolutely critical. There's no way in my small little veterinary practice I was able to delve into the pluses or minuses of the various insurance products that are out there. So these folks are absolutely essential, I think, to make sure that small businesses keep their health care costs down, which is the ultimate goal of the Affordable Care Act. So want to really work with the group out here and see if we can modify some of the rules that are coming out and make sure that you guys are part of the benefit, not part of the problem going forward. So thank you all for coming here. I yield back.
Thank you. If subcommittee members have an opening statement prepared, I ask that they submit that for the record. I'd like to take a moment to explain the timing lights for our witnesses today. You will each have 5 minutes to deliver your testimony. The light will start out as green. When you have 1 minute remaining, the light will turn yellow. Finally, it will turn red, and at the end of your 5 minutes, finally it will turn red to signify that you're at the end of your time, 5 minutes. I ask that you try and adhere to the time limit. It's a pleasure for me to welcome our first witness, a fellow Coloradan and constituent, Mitchell West, to the subcommittee. Mr. West is an independent insurance broker with Health Choice One in Greenwood Village, Colorado. He provides customized assessments of insurance products for small business clients and assists them with any claims. He holds a BS from the University of Southern California. He is testifying on behalf of the National Association of Health Underwriters. I must also mention that Mr. West and his wife, Jamie, have 3 children. Their son, Trenton, graduated with honors from the U.S. Air Force Academy and is currently stationed in Seattle, Washington. As a U.S. Marine Corps combat veteran, I commend your son for his service to our country. Mr. West.
And I am an independent broker in Centennial, Colorado. And I believe I share the sentiments of the 22,000 licensed agents in Colorado, as well as the over 1 million agents across the U.S. I am a small business owner. I have 1 full-time employee, and this is typical of health insurance agents. I'm glad for this opportunity to address what the MLR has meant to us as we've moved forward since its implementation this year. I have a bachelor's degree in biomedical engineering, followed up by graduate course level work in industrial systems engineering, electrical engineering, and business administration. In 2002, I was thrown into a new environment. I was laid off as a result of the dot-com and telecom busts, and I had to find health insurance for my family. And I'd never been there before. In spite of my background, all the training I had, I was inundated with information. I couldn't make sense of it. I couldn't discriminate between what was good, what wouldn't be so good. And at that time, it was only with the help of a professional agent that I was able to figure out what to do. And boy, was I glad that I did. I realized what the mistake was that I might have made if I'd progressed on my own. A couple of months later, I began my career as a licensed agent, and that experience was fresh in my mind. As I met with my clients, I began to understand that they all had a common element. They had more misconceptions about health insurance than they had real facts, and they did not even know what questions to ask as they were seeking to figure out what would be best for themselves and their families. I've since worked with over 5,300 clients in 27 states, and I've come to the realization that my primary job is to educate my clients. In my written testimony, I've listed 14 areas and topics which I consider to be essential in covering with my clients. And while this is a very time-consuming approach, I think it's essential, and it's very much appreciated by my clients, and why I have hundreds and hundreds of clients that have been with me for over 8 years. None of these activities generate 1 penny of revenue for my business. My only source of income is the commission stream paid after the sale of health insurance policies, and all of these commissions come through the insurance companies which I represent. As a direct result of MLR requirements effective January 1 this year, every insurance company I represent, without exception across the United States, severely reduced commission levels. My overhead expenses are unchanged for 2011, and in fact, they'll go up next year. The net result to my practice has been a decrease to my bottom line of 50%. You all have business experience. You can imagine the gravity of a 50% impact to your bottom line as a small business. Many agents, especially those that were in the building phases of their practices, have simply exited the business. They just couldn't make cash flow. Others have chosen to move into other areas of insurance where they can be more successful. And for the majority of remaining agents, the current situation is not sustainable in the long run. Millions of Americans are in need of health insurance for a variety of reasons. Put yourself in their shoes. The health insurance environment has never been more complex and confusing, and they've never been more in need of professional assistance. I cannot stay in business operating the way I used to, and so my time must be allocated differently. Pro bono work, I just can't do it anymore. I will be forced to spend less time with all of my current clients, and that inevitably means in the long run they will pay more for their insurance and gain lesser benefits. Insurance companies are also cutting staff for the same pressures and reasons that we are. So the double whammy of insurance agents being restricted and insurance companies cutting back on support staff is a negative impact to the consumers in general. HHS was given sole responsibility for implementing and defining the MLR calculation, and they have the power to recognize these facts and make changes. Despite the best efforts of industry groups, consumer groups, the National Conference of Insurance Legislators, the National Association of Insurance Commissioners, and many members of Congress, HHS has been unwavering in their position and has chosen to not act. Therefore, the only solution is a legislative one, and it is needed immediately. Much damage has already been done to tens of thousands of agents and numerous consumers nationwide, and the tide must be changed, and it must be changed before the agent community reaches a point of no return. I appreciate the opportunity to share these thoughts. MLR is an example of legislation which I think has resulted in unintended negative consequences to both small business and consumers, and members of Congress need to be aware of these facts, and on behalf of the American people, to work with a sense of urgency to correct these issues. There's significant more information in my written testimony, and I hope that will be helpful to the committee. Thank you.
Thank you, Mr. West. And now yield to Mr. Bartlett to introduce Gary Livingood.
Thank you very much. It is really my pleasure to introduce our next witness, Gary Westfall Livingood. He is a graduate of West Virginia Institute of Technology with postgraduate training at the University of Maryland and University of Virginia. Mr. Livingood has a background which really is relevant to what we're discussing today. First of all, you started out as a journalist in the U.S. Army. Thank you, sir, for your service. You organized, developed, and directed all functions for claims offices in a 29-state region for a self-insured rail transportation corporation. You directed the overall marketing and operational efforts for a 14-office company, one of the nation's largest investigative services companies. You had operational responsibility for a 200-member cost containment department within a large regional health maintenance organization, really relevant to what we're talking about today. And now you are principal of What a Stitch for operational, financial, as well as federal and state compliance responsibilities for an embroidery small business with 21 employees, providing apparel enhancement for companies and individuals, principally throughout the Mid-Atlantic region. Thank you very much to Capitol Hill and our hearing.
Thank you, sir, and good morning. As I was indicated, my name is Gary Livingood. I am a principal with What a Stitch LLC, which is a small commercial embroidery business in Mount Airy, Maryland. I'd like to thank the members of the Small Business Committee for the honor of testifying before you today about the health reform law. Tell you a little bit about me. After serving my country in Vietnam, I worked in a variety of operational positions from various industries for over 35 years. Then my wonderful wife, Luann, somehow got me to agree not to spend my retirement on the golf course like I planned, but rather on helping to grow her hobby into a business that now employs 21 people. We started What a Stitch in 2002 with one single head sewing machine. The company grew and grew, but then like business owners everywhere, 2008, 2009 hit. We're very committed to maintaining the business and keeping the employees, so we dug very deeply into our personal savings just to keep the doors open, and we were able to do that. Times still aren't great for us, but they're better than what they were. I wish I could say that even better times were ahead, but unfortunately the future continues to look uncertain. I know the intent of the new health law was to help business owners like us, but thus far I don't see it. The new law weighs heavily on my mind anytime we're thinking about hiring new employees or what the future may bring for our small business. It's already put regulatory burdens on our company, and then I suspect that there are more compliance issues that are going to be coming forward. Before we started What a Stitch, my wife was a director of human resources with Amtrak, and I spent my last 13 years as a vice president of operations with United Healthcare, well, eventually with United Healthcare. So we may be a little bit more conversant about the administration of group health insurance than your average day-to-day small business owner. Consequently, the day-to-day reliance on our healthcare agent, Paul Yonkins, who's also the co-owner of Allied Resource Management, isn't as extensive as many small business owners. But even with our experience, Luann and I just wouldn't consider dropping the services of our agent. He's our insurance policy within an insurance policy. And so far, our company's been very lucky. We haven't had claims, disaster, or medical crises that require the full use of Paul's capabilities. But I know that Paul and some of his clients do, and other agents like Paul have far-reaching services to small businesses across the country. But I understand that our company could experience similar needs at any point in time. If and when that day comes, I want employees and the family to have somebody that we know and can trust at no additional cost, so that my wife and I they'll get the job done for us, and my wife and I can concentrate on keeping the company profitable. Paul, on the other hand, is a businessman like me, and he deserves to make a fair living. And when I pay our company's insurance premiums each month, it's clear that a portion of my check is really our agent's fee. That's included in our tax bill and for tax and convenience purposes. It's also obvious that our company's total insurance premium rate has nothing to do with the amount the agent gets paid. Our premium costs are driven by the cost of medical care in Maryland, as well as the age and the size of the group of our employees. Paul's fee is just a small percentage of whatever our insurance premium will be, and it's worth every penny. Unfortunately, it's my understanding that the new health reform law's medical loss ratio requirements are hurting Paul's business and similar business nationally. My company went through several years of declining revenue, so on a personal level, I feel for Paul. But I worry about the impact that it's going to have, and if Paul needs to change the nature of his business and can't afford to handle our account anymore, we may have to seriously consider just dropping our group coverage, saving the money that we put into our employees' premiums. And if the government takes over such benefits and administration, I'm hard-pressed to believe that we will continue to have the same kind of access to customer service that Paul currently provides. And I see my time is up, so I thank you for the honor of testifying before this committee today.
Thank you, Mr. Livingood. Who would introduce? Do I introduce? Okay. Thank you. Our next witness is Grace Marie Turner. Ms. Turner is president of the Galen Institute, a public policy research organization that she founded in 1995 to promote free market ideas for health reform. Earlier in her career, she was executive director of the National Commission of on Economic Growth and Tax Reform, and served as president of Arnett and Company, a health policy analysis and consulting firm. Welcome. You have 5 minutes to present your testimony, Ms. Turner.
Thank you, Chairman Coffman. Thank you for holding this hearing. Thank you, Ranking Member Schrader, Congressman Bartlett, West, Landry, and Tipton for this hearing today. I think it's tremendously important to look at the impact of this otherwise obscure and complex regulation on the real world of health agents, health costs, businesses, and job creation. The Affordable Care Act already is leading to a loss of affordable options in health insurance for small employers. It's leading to a loss of jobs inside and outside the health sector, and to higher health care costs that make hiring workers more difficult, especially for struggling small businesses. Large employers can self-insure and better insulate themselves from the early changes inflicted by the health law, but not so small businesses. They're more exposed to changes in the marketplace. And as I document in my testimony, many carriers already are leaving the market for individual and small group insurance. When fewer carriers offer insurance and when fewer options are available for coverage, small businesses are hit first and hardest. The percentage of small businesses offering health insurance has declined from 68% in the year 2000 to 59% in 2011. The health law that so many small businesses had hoped would benefit them by lowering costs is instead harming their ability to continue to offer health insurance at all, at least partly because of early provisions in PPACA. Premiums in the job-based health insurance market rose in 2011 by an average of 9%. By $1,300 a year for a family to $15,000 a year for a policy. The medical loss ratio, which mandates that health insurance carriers spend most of their money on premiums, is contributing to dislocations in the small group and individual market. A growing number of carriers are leaving these markets because of HHS inflexibility in interpreting the law. One of the tools that small businesses have found to be most valuable in helping them to afford affordable coverage has been high deductible health care costs have been are likely to be an early casualty of the MLR rules. They discriminate against these high deductible plans because the MLR regulations only count payments made directly by insurers as medical expenses. That means that if an individual pays for a health care service to meet the deductible, the expenditure doesn't count toward the MLR, even though the full amount is actually a payment for medical services. So it's an interpretation by HHS that is going to particularly disadvantage the high deductible health savings accounts and other account-based plans that health insurers and small businesses have found to be most affordable. Companies that sell policies in the individual and small group market also have higher marketing costs and higher customer service expenses because they provide services, because they have to sell the policies one-on-one, and because they are really helping their clients to find the most affordable policies that they can with the resources they have. One of the perverse effects of the MLR rules likely will be higher health care costs, not only because they are shoving out competition and giving carriers fewer options, giving the remaining carriers the opportunity to increase their health care costs, but also because, again, of the HHS interpretation of the laws, which, for example, say that costs in ferreting out fraud have to be considered in the administrative costs rather than as part of the overall cost or excluded from the total. The medical loss ratios also are job killers, as really is this whole law. The president of the Federal Reserve Board of Atlanta recently said, "We've frequently heard strong comments to the effect that my company won't hire a single additional worker until we know what health insurance costs are going to be." And as we have heard, the first line of impact is in the broker community, where a survey found that at least 21% of independent brokers already have been forced to downsize their businesses or even close their doors. As you mentioned, Mr. Chairman, the National Association of Insurance Commissioners has adopted a resolution urging Congress to amend the federal health law to protect broker commissions from the medical loss ratio so that they can continue to provide the valuable services that they do. In conclusion, one of the most fervent promises that President Obama made to the American people when this law was ramping up toward passage: if you like your health plan, you can keep your health plan. Period. No one will take it away, no matter what. Clearly, before the law even takes effect, we find that's not true. I detail in my testimony many states in which carriers are already leaving the market. that will impact small businesses first, because the small group and individual market are particularly difficult for carriers to meet this new test. As people are having their carriage disrupted, violating the promise that President Obama made, I am sure that the American people are going to look for other options, and I look forward to working with you and other members of the committee to achieve the real goals of health reform.
Thank you, Mr. Turner. Ranking Member Mr. Schrader, for an introduction of Mr. Jost.
Thank you, Mr. Chairman. It's my pleasure to introduce Professor Timothy Yost. Thank you for being here. Professor Yost teaches law at Washington Lee University School of Law. He's co-author of a casebook, Health Law, used widely throughout the United States to teach health law. Professor Yost is author of numerous articles on healthcare regulation and comparative health law and policy. And he's also a consumer representative to the National Association of Insurance Commissioners. Professor Yost earned his J.D. from the University of Chicago, cum laude. Very good, 1975. Come from Illinois myself. So welcome, Professor Yost.
Thank you very much, and thank you, Chairman Coffman, for the opportunity to speak today, and Ranking Member Schrader and committee members. Of all the Affordable Care Act health insurance reforms already in effect, the most beneficial for American small businesses is the minimum medical loss ratio requirement. The cost of health insurance is one of the largest and fastest growing items in the budgets of small businesses. Fortunately, the MLR is bringing relief. First, relief will be coming through rebates. A study conducted by the NAIC last spring found that $450 million, $500 million in rebates, would have been paid to nearly 16% of American small businesses, and 23% of all employees had the rule been in effect in 2010. This year, when the rebates are actually paid, the amounts may be larger. But the purpose of the MLR is not to generate rebates, but rather to reduce premiums. The MLR produces a strong incentive for insurers to reduce their administrative costs and thus their premiums. But the real driver of insurance premiums is medical costs, and the most important benefit of the MLR is that as medical costs come down, premiums will be reduced accordingly. Medical cost inflation, in fact, has fallen precipitously in the last couple of years, and as medical inflation declines, the MLR will force insurers to pass the savings directly to consumers. Already last summer, the GAO report that Chair Coffman mentioned said that the MLR was driving down premiums. Aetna in Connecticut recently dropped its premiums to small groups by 3.2%, while Mountain State Blue Cross in West Virginia announced yesterday that small businesses like Mr. Livengoods will be getting an average reduction in premiums for December of $2,500 for 4,200 small businesses, a 75% reduction in their premiums. Jim Hauser, a small businessman from Portland, Oregon, reports that his premiums went down 3% this year, and he was told it was because of the MLR. Brian England, small business in Columbia, Maryland, saw his premiums go down 6% because of the MLR. Some argue, however, that the MLR is destabilizing insurance markets. But as another recent GAO report found, most insurers were already at 80% before the rule went into effect. The HHS rule provides special treatment for new market entrants, for small plans, for high deductible plans, for limited benefit plans, and for expatriate plans. And I would really encourage you to read the rule. It's very widely misunderstood. It allows insurers to exclude fraud recoveries and to claim credit for health quality improvement costs, including the full cost of ICD-10 conversions, up to 0.3% of premiums, which for most will be their full costs. States also can request MLR adjustments if they believe that it's going to destabilize their insurance markets, but 2/3 of the states did not do so because they did not believe they would have problems. Ms. Turner's testimony includes a long list of insurers leaving particular markets. I read through all of the citations of sources, and virtually none of those withdrawals are due to the MLR requirement. An example of this, Indiana, in its request for an adjustment, claimed that 7 insurers were leaving the market. 4 of those would not have had to pay rebates under the MLR rule because they were too small or because they already met the MLR. 2 said they were leaving for business reasons. 1 had not even started selling policies in the state yet. None of them claimed that they were leaving the market because of the MLR. The most vociferous protests against the MLR requirements have come from agents and brokers, and I certainly understand the valuable services that they provide and their need for compensation. There's some evidence that insurers are cutting compensation, although the picture is complicated, as the NAIC found. Many are not. But it's not at all clear that those cuts are to be blamed on the MLR. For example, in Colorado, every single health insurance provider met the 80% requirement before the MLR rule went into effect. So although I don't doubt that Mr. West's commissions have been cut, I don't think it's the fault of the MLR. Cuts in agent and broker commissions are occurring because of business decisions of insurance companies, and they are blaming it on the MLR. If Congress took commissions out of the MLR tomorrow, insurers would probably not raise commissions. They would simply take the money for profit. Finally, Congress must consider what a legislative change would mean for the deficit. Employer-sponsored health benefits are heavily tax subsidized. As the MLR drives premiums down, tax subsidies will go down as well. If you add commissions to the administrative expense insurers already charge for small business, and that is what the Rogers bill would do, you're increasing the cost of small businesses for doing business. You're increasing their premiums, but you're also increasing the federal budget deficit by billions of dollars. Any attempt to eliminate the MLR rule or to change it to allow insurers to keep spending unchecked can only raise costs for small businesses and indeed for all insured Americans. I encourage you to support small businesses by keeping a strong MLR. And let me just say, although I'm a second over, that I was involved extensively in the NAIC's drafting of the MLR rule. I've followed it very closely, and I would be very happy to talk to you about what the MLR rule actually says and does. So thank you very much for your time.
Thank you, Mr. Yost. Let me start out with a few questions. To Mr. West, first of all, to you. The 8 major health insurers in Colorado have reduced agent commissions as a direct result of the new MLRs. Would you elaborate on your situation and that in Colorado?
Yes, I can. The average composite, and I'm speaking from my book of business, approximately 1,200 active folders serving a couple thousand people, the average commission reduction was about 47% on the individual insurance markets, pre-January 1st, 2011 to post-January 1st, 2011. I also am licensed and have clients in 27 other states. Every insurance company in every state across the United States with which I am appointed and do business had similar reductions. And I can tell you that it was impacted by the MLR guidelines because insurance companies could not have met the guidelines and maintained previous commission levels. I mean, the math is just clear and very direct and obvious. So it was an instantaneous impact that took effect at the stroke of midnight on New Year's Eve last year, and it affected every carrier that I work with.
Okay. With the new MLRs, you said you are forced to spend time selling other products to maintain your income. How does that affect your company and your small business clients?
Well, it is forcing me out of supporting clients in the health insurance domain. Other areas for other types of health insurance products, financial services, of course, were not affected by the MLR. So I, like many of my associates, have been forced into those spaces in order to be able to keep my business alive. I still do active work with my current clients, but I also have to curtail my support for them. I can't do all of the aftermarket support. I can't help them with claims issues, problems with their policies. I also can't be proactive as much as I would like to be in terms of professional development and staying abreast of changes so that I can, in the same manner I did before, call them in advance of new impacts and changes and advise them how to adapt their coverage for best benefit. So I'm just being forced, if you will, into a different business model, and it's my health insurance clients that are going to suffer as a result.
Okay. Let's see, Mr. Schrader.
Thank you, Mr. Chairman. Good testimony. Appreciate everyone taking the time out of your busy schedules and trying to get our economy going by doing business to come here to Washington, D.C. and enlighten us a little bit on the MLR. I guess I'd be interested in everyone's opinion, but Mr. Yost in particular, some of the other issues that have been discussed is that while the MLR takes into account fraud and going after fraud as a positive benefit in the law, there's not a lot about prevention. It seems to me that a lot of insurance companies and agents are dissuaded from pursuing early intervention and prevention because they don't get the same benefit under laws. Was that discussed at all during the NAIC hearings and such?
Yes, and in fact, that is expressly accommodated in the rule. What the statute does is allows the rule, the regulation that HHS was supposed to produce with the advice of the NAIC, to put into the denominator in calculating the MLR both health care costs and health care quality improvement costs. The NAIC spent a long time debating what quality improvement meant and decided that it didn't include brokers' commissions, but that it did include money that insurers spend on improving patient outcomes, protecting patient safety, preventing medical errors, specifically prevention and wellness activities, and a lot of thought was put into that, and then also supporting IT conversions and ICD-10 conversions now, and accreditation costs attributable to quality. So in fact, wellness and prevention activities are explicitly countable in the numerator. They go into the 80%, not into the 20%.
I get those citations if possible.
Sure.
Obviously, there's some misunderstanding
Yeah.
out there about that. I guess I'd go to Mr. West on this in terms of talking about how small businesses are harmed by the, including the commission fees in the MLR and stuff. Could you elaborate in ways that we might be able to get around that a little bit? What are some of the other options? I've signed on to some bills, but I'm curious your view as to ways we can alleviate some of the negative effects by including commissions in the MLR at this point.
Well, the first and foremost impact is on the small businesses that are in that space, the health insurance agents, the people they hire, the businesses they run. As I said, it's immediately evident that if a business overnight suffers a 50% reduction in bottom line, I can't expand. I've chosen for my employee not to cut her salary 50%. She wouldn't be able to survive. So I've had to eat that out of my small business. So you can imagine if there are 1 million licensed agents across the United States, any significant percentage of an impact there translates into jobs, and it ripples through the employees and support structures. I have about a 30% overhead rate in my business, and that is paid out in terms of services and contract labor, and there's all kinds of other trickle-downs from the effect on my small business. The other effects to other small businesses, perhaps small businesses that I serve, have to do with the fact that it takes more time and effort to work with those clients as we try to solve their business needs, and that time is just no longer available to spend with them, and there is no other place that they can turn in terms of gaining that professional support, and that can be critical in terms of optimizing coverage, saving premium dollars, and in the long run can be very substantially impactful to those small businesses. So from my perspective, undoing that impact that was done moves us back at least to the status quo before, in which people were willing to put in that time, develop their businesses, and work on behalf of those consumers and small clients that are the core of my business today.
Very good. Ms. Turner, Mr. Yost, curious as to what the potential remedy would be in your minds if we were to exclude commissions from the basic MLR, since the goal really of the MLR was to improve efficiency. And I don't know if I'd be curious about comments. I don't see how agents themselves are inefficient. They actually provide a pretty good service, as Mr. West just testified to, and just giving small business people that have no background. You guys have background. I have no background in health insurance. Well, I'm a veterinarian, but other than that, I don't have a whole lot of experience. I can fix your horse, but But I'd be nice to, I just don't see the agents as overhead. Doesn't strike me as they're more of an informative. They keep my costs down because I don't have to spend, or my office manager doesn't have to spend a lot of time on that. But I'm also concerned about, with all due respect, not that this would ever happen, but insurance agents gaming, including commissions, and they'd slip some other costs in there that indeed would be part of the administrative overhead that we'd like to see them try and get down on their own. So what is the sweet spot in any sort of solution going forward here?
Well, I think, thank you for that question. I think that the excluding the commissions from the MLR calculation makes the most sense, because they're not going to the insurance company, and yet the insurance company would rather take whatever, that whole 20% for itself rather than pay brokers, even though they are providing, as you say, valuable services to their clients, not only in finding more affordable policies, but often serving as external HR departments for small businesses and helping with complex claims, et cetera. So the costs are there. They'll be borne by small businesses, they'll be borne by companies that are going out of business, and they'll be borne by businesses that have fewer options for affordable coverage, both because they don't have the brokers to help them find it. So those are real costs. They're not going away. And whether or not they fit in with some artificial calculation that HHS has determined is really not the point. They're valuable, and I think, therefore, it should be excluded from the calculation entirely.
Mr. Yost?
Yeah, the effect of the Rogers Bill, 1206, of excluding brokers' commissions from the calculation is not to give money directly to brokers. It's to increase the amount that insurance companies can keep. In other words, if the insurance company is now paying 10% and keeping 10% for its administrative costs because it has a total of 20, it can now keep 30%. And it will undoubtedly raise premiums or cease reducing premiums to account for that. Now, it may share some of that money with the brokers. If they're paying 5% now, that they can keep that 5%, paying that to, and that's the average for insurers for small business commissions. They can keep that 5%, but they now get 20% on top of that, and they're going to raise the premiums by that 5%. So the effect of the Rogers Bill is simply to raise premiums for small businesses. And hopefully insurers will share some of the extra profits they make with commissions. And don't trust me, Carl McDonald, Citibank's investment analyst, put out a report right after the NAIC had its vote and says this is a big deal for insurers. They're going to make a lot more profit, and they may share some of it with brokers. The NAIC worked out a number of recommendations for legislation that would allow commissions to be passed through, but then reduce the administrative costs for insurers correspondingly so that consumers wouldn't be hurt. And if people feel that brokers need legislative relief, I would strongly encourage you to look at those alternatives rather than the Rogers Bill, which simply increases premiums for small businesses and insureds and passes the money on to insurers in the hope they might share some. And let me just say one other thing. Although it's entitled the Independent Brokers and Agents Bill, the way that is defined would include employees of insurance companies who sell policies as well. And so insurers could pass all of their marketing costs on to consumers and to small businesses.
Very good. Well, I'd be interested in that at some point in time also.
Sure.
And maybe the committee. Thank you, Mr. Chairman. I yield back.
Let me make one point and ask for any comment from any of the members of the panel. First of all, I want to say it's amazing to me intellectually how we've come to this conclusion, whereby the federal government is enacting policies, assuming based on the Commerce Clause that it has jurisdiction in this particular area, where we don't allow small businesses to purchase across state lines today, and how that we can impose rules that in fact regulate commissions is extraordinary. I think how to bring down cost is to allow the market to work. And I think one of the problems with health insurance in the United States today is we have a regulatory regime that really I don't think fosters competition between insurance companies. And so one of the concerns that I have about this particular policy is I think that there's perhaps a perverse incentive built in that, and I remember having been a state legislator where debating one day a particular mandate on a health insurance company that clearly would have raised cost. on small businesses on their premiums, and going down to the floor to debate the sponsor of the bill, and I said, well, why is the public sector exempt from your particular mandate? And she said, well, because it costs too much. Well, you know, I mean, it's extraordinary, but we keep putting these things on small business. Well, every time you do that, obviously you create an increase in cost, but the beneficiary of the increase in cost under this regulatory framework is going to be the insurance carrier, because it's one way, I think, that this is built in, that the higher your premium costs, the greater your profits, not by competition. And so I think that this is inherently problematic. But would any of you like to comment on that? Ms. Turner? Yeah.
I think that that's really a risk. I mean, many factors go into the cost of health insurance, and its utilization. It's the prices that the insurers are forced to pay. And in a competitive market, you're going to find if you have more competition, then those administrative costs are going to get wrung out. But when you only have a few carriers left in the market because the competitors that have lower overhead actually have been shoved out, you're going to drive up health care costs. And this allows, if a carrier is looking to maximize its 20% and it has less competition, then it's going to be able to raise the overall premium so that that 20% represents a larger number of dollars. And so I think actually the MLR rule, by driving out competition, and hopefully I'll have a chance to talk about some of the challenges to my testimony, by driving out competition is actually allowing the few carriers that are left to increase premiums, to therefore maximize their share of that 20%. And with less competition, who's going to stop them from doing that?
If I could respond briefly, the Affordable Care Act actually contains a number of provisions that will increase competition, and I readily admit that some insurance markets, many insurance markets, are highly concentrated. One of the things it does, and this program is actively underway right now, is to introduce consumer cooperatives. We have those in a handful of states, but there's seed money in the bill for loans to establish consumer cooperatives, and there's a lot of interest in that. Another thing the legislation does is to provide that OPM is supposed to provide multi-state plans in every state, so that there will be at least, just like it does in FEHBP, so that there will be at least 2 plans in every state that will be new, and well, they will be multi-state plans that will be available to establish competition with existing plans. Another thing the legislation does is that it actually does allow sale across state lines with some controls, and not immediately, but it does provide for that possibility. That's something state insurance commissioners are very concerned about, because they then lose the ability to police what's happening in their states. But with appropriate controls, I think it's a good idea, and it's in the Affordable Care Act. With respect to regulating the markets, one other response, and that is, if you look at the actual medical loss ratios of companies, what you find is that the really big plans, the big Blue Cross plans, are there already. They have 85, 90% MLRs and have for a long time in most states. It's the small insurers that have high administrative costs. But the legislation and the regulation takes account of that, because smaller insurers actually have reduced MLRs, and high deductible plan insurers have reduced MLRs. So they have an easier target to hit. So a lot of these problems have already been taken into account in the regulation.
More freedom might be a solution, but are there any other comments? Yes, Mr. West.
I checked with my assistant this morning before the hearing, and there are 58 client folders on my desk right now. And these are clients that have all been affected by 2 major insurers in the state of Colorado exiting the entire market space. And there's a bunch of factors that go into that. But I'm looking at a backlog here, a tremendous amount of work to work with these clients to understand what to do next, and how to save them from becoming uninsured, which is what they're staring at, okay? I can tell you that my clients are mystified by what's going on, just in general. We've seen in the state of Colorado in the past 18 months an average individual medical commission increases, if I average out all the plans over all the companies, of about 27%. And the customers don't understand why, and they're frosted, I guess is the best way to say it. The one thing that they would be willing to pay for is my services, but I can't collect those services. It's for a bunch of regulatory reasons, which are different in every state and every market that I work. We are prohibited from charging direct fees in some markets. If we were not prohibited, just the inefficiencies of the process of me having to negotiate fees and services with every client and collect and bill would be prohibitive. And so the direct impact of the MLR, which is easily accounted for, which resulted in this 50% reduction in commissions, makes the entire situation untenable. And upon request, I'm happy to do a random sampling of my 1,200 clients, and we can call them and ask them, but the last thing they want to do is see me provide less services to them. That may be the biggest value-added component they see in the entire process right now.
Thank you, Mr. West. The other Mr. West from Florida. Oh, Mr. Bartlett from Maryland, please.
Thank you. You know, if you think about it, essentially all of our regulations are based on one of two premises. The first premise is that every employer, provider, or manufacturer is inherently incompetent, evil, or greedy. And they're going to screw the employees and the consumers if we don't protect them with regulations. And the other premise is that every consumer is really incredibly naive and ignorant. And if we don't have a bunch of regulations to protect them, they're going to get taken advantage of, and they're going to hurt themselves. And this regulation is no different. I know it was well-intentioned, and it was intended to reduce the cost of health care, but I think it will do quite the opposite, because there has to be a cost of compliance here, and that can do nothing but drive up the cost of health care. If, in fact, insurers are making excessive profits because they're paying out too little of the premiums in health care, if we have an open competition, will not new insurers come into the market to share in these profits and therefore drive down the cost of health care? You know, our problem is that our regulations are preventing competition. And competition, I think, will do what this regulation is intended to do, but cannot do because it will simply increase the cost of compliance and therefore drive up the cost of health care. Why shouldn't we reduce regulations and let the market drive down the cost of health care?
Mr. Bartlett, you could not be more correct. In Virginia, across the river from your state, a company called InHealth announced right after the health law passed that it was closing its doors, a new innovative offered primarily high deductible plans, because it saw this regulatory steamroller coming at it, and it basically lost investor support. So people lost that opportunity for this new innovative company to provide those options. Unicare has basically left the individual market in Virginia, leaving about 3,000 policyholders without their options. So the lack of competition, and you're so right about the regulatory compliance. When you look at this MLR regulation, page after page after page, about how insurers have to document their medical loss ratio. So that's it costs them money to prove, to go through administrative hassle to prove to HHS that they're going through the right administrative hoops. So it's chasing our tail. It's completely, it's working against ourselves and actually thinking about consumers. And you're so right. People have said, healthcare is just too important to be left to consumers. Well, it is not. People are smart. If the market will respond if those options are available, but they're being crushed by regulation.
If I could respond briefly, I went to the University of Chicago, so I believe in market competition to a point. World Insurance Company, one of the companies that is leaving Colorado, was fined $153,000 by the Colorado State Department of Insurance for a number of marketing problems, including the fact that it excluded coverage from skiing as a high-risk activity. Well, in Colorado, a lot of people ski. And so I think that when a company is fined or is even barred from a market for regulatory purposes, sometimes it is a good thing and sometimes it helps consumers. Not everybody who wants to sell insurance should be allowed to do so. With respect to competition, though, in insurance markets, it's really complicated, and health economists have studied this for years. Just an example of this, I heard the other day, and I can't substantiate this, but I believe it's probably true, that in one of the states where a new cooperative was trying to form under this new law, one of the big insurers had gone around and told providers, if you sign a contract with them, we're going to terminate your contract with us.
But, sir, if we had open competition, and if we didn't have regulations that kept new people from coming in, wouldn't the marketplace take care of this?
I don't believe so.
You don't believe so?
No. I think if we did that, we would have basically about 2 or 3 national insurers in every state.
Sir, that can't be true if other people can come in. We're now going to have fewer and fewer insurers because your regulations are driving them out of the market, and you're achieving exactly what you set out to avoid with your regulations. Thank you, and I yield back, Mr. Chairman.
Mr. West of Florida.
Thank you, Mr. Chairman, Mr. Ranking Member, and thanks to the panel members for being here today. And you know, I'm a simple soldier, and I appreciate your son serving in the Air Force, and I appreciate your service in Vietnam, where my older brother served. And to me, this seems like another example of we have to pass the bill to know what's in it. Because now we're all of a sudden seeing again that the unintended circumstances, and I think that this once again represents a rule, a regulation, whatever you call it, that is counterproductive to what established this country and made it great, and that's the free market and free enterprise system. I mean, just the same with Dodd-Frank. We're finding out with Dodd-Frank we have more problems with our small community banks and their relationship with our small business owners. And the same thing with this here now. With the Patient Protection and Affordable Care Act, we find another provision that is causing more problems for our small business owners. So my initial question is to Mr. West, Mr. Livingood, and Ms. Turner, is what do you see as the most detrimental effect of this new MLR rule, regulation, whatever you call it, within your respective lane?
I'll go first. I'm aware that it has become caused an impact upon my agent's revenue stream and his ability to possibly attend to my needs as deeply as he did in the past, because I rely upon my agent heavily. I have implicit confidence in his ability to perform. When I have issues that arise, and that's not often, but when I have issues that arise, I pick up the phone and say, Paul, you have a problem. And I tell him what the problem is. And then I hang up the phone, and I know that that problem is going to get resolved expediently and to the best benefit that possibly that could occur to me. So as I see him being concerned about, do I want to still stay in this market or do I want to do something, that causes me great concern. Because if he weren't performing, same as my CPA, my attorney, et cetera, if they weren't performing, I have immense leverage. I can terminate the services. If we're dealing with some other entity, such as an insurance exchange, I think I've lost that leverage. But that's my observation of the most immediate impact.
Mr. West, I think that the biggest problem is just this Washington knows best attitude. I mean, states are the regulators for health insurance, and they can solve problems when a company may go against some regulation about whether or not skiing is included. That's not a federal government problem. And yet states have had to go through amazing paperwork burdens, regulatory to work to create petitions to Washington to exclude them from the medical loss ratio rule or to give them some relief. And HHS, in its wisdom, has told states like Indiana, I'm sorry, we know best, not you. And Mitch Daniels, governor of Indiana, said that that denying Indiana the waiver from the MLR rule is going to lead to higher costs, and it's working against personal freedom. And he says, for example, that in Indiana, they have a disproportionately high number of people with health savings accounts. And therefore, because, again, of this obscure provision in the rule, it's particularly difficult for HSAs to meet that test, even though it's affording businesses and the state more affordable coverage. And to Dr. Jost's comment earlier, a number of companies have said we are leaving not just because of the MLR, but because of this burden of regulation of which the MLR is a part. The American Enterprise Group announced in just this October that it's leaving the market in 20 states. The MLR is a big contributor. Aetna is leaving the market in many states, including Colorado, because it's saying that it can't meet the test in the individual and small group market. So you're losing the exact competition that you're talking about because states are asking Washington for relief from the MLR rule, and Washington is telling them, no, we know better than you do what's right for your health insurance markets. I think it's that arrogance that is really the root of the problem.
Congressman, I would use the case of World Insurance in Colorado as a perfect case study. World Insurance was a relatively small insurer that entered the state. They were very creative with their policy definitions and offered an extremely high-value product, and that product was based on two premises. One, giving the consumer the ability to tailor their coverage to their needs. The fact that they defined skiing as a high-risk activity was not evil. It was not illegal. It was simply part of their product offering. Very interestingly enough, they also entered into a partnership with agents, and they offered a higher than average commission rate to agents with the understanding that we as agents would represent the company in a way into properly delivering that product to consumers. While there are a lot of skiers in Colorado, 95% of the residents in Colorado do not ski, and they enjoyed the opportunity to knowingly select a plan that wouldn't cover skiing injuries at a substantial premium discount. The direct result of the MLR calculation and many of the other factors inherent in the legislation was to deem those sorts of practices to be somehow wrong, and World Insurance has left the market space. I can tell you for a 2-year period, the World Insurance product was the one that I owned and that I recommended for the vast majority of my clients based on lowest premiums and best value delivery to those consumers under the appropriate circumstances. The moment that I learned from a client or we discussed the issue and he told me I'm a skier, I would immediately say, well, then we need to move to another product. Those choices have been all but eliminated from the marketplace now. And the results of the legislation is decreased competition. This company has left the space. Their highly effective, cost-effective premiums are no longer available to my clients. And I would tell you, as a former customer of theirs, there was nothing wrong with the product they delivered.
Thank you. Can I continue on, Mr. Chairman? And Mr. Ranking Member, if that's Professor Yost, I have a letter here you recently signed on to members of Congress about the medical loss ratio. And the letter states in part that the NAIC unambiguously concluded that a year ago producers' commissions are an administrative cost. And you participated in the NAIC's fall 2010 meeting. As a matter of fact, I'll read the statement out of the letter that as the NAIC itself concluded a year ago, after extensive deliberations, producers' commissions are an unambiguous administrative cost. But at that 2010 meeting, fall 2010 meeting, the NAIC took no action on these brokers' commissions. And in fact, since the January 2010, they've been urging Congress and the HHS to accommodate brokers' commissions in the medical loss ratio. And I want to read from that NAIC report where it says, In a recent letter to HHS Secretary Kathleen Sebelius, the NAIC reiterated the important role of insurance agents and brokers. Director Hudson stated that the NAIC encouraged Secretary Sebelius to recognize the essential role of insurance agents and brokers and to accommodate compensation arrangements in any MLR regulation that is promulgated. Director Hudson made a motion, seconded by Commissioner Savegny, for the NAIC to appoint an executive committee level subgroup to work with HHS to accommodate agent and broker compensation in the MLR, particularly during the transition to 2014, and the motion passed. So my question is, why would you sign on to a letter that actually contradicts what happened at this NAIC meeting?
Thank you for an opportunity to comment on the NAIC's involvement in this issue, because it's a complicated story, but I'll try to keep it brief. The NAIC's task under the statute was to come up with definitions, establish definitions and methodologies for implementing the statute. The statute does not permit either HHS or the NAIC to remove agents and brokers' commissions from the denominator because it's not there. It allows taxes, regulatory fees, various other kinds of adjustments, not agents and brokers' commissions. So the NAIC recognized that when it unanimously adopted the recommendation, I believe it was unanimous, on the NAIC rule last year. However, the NAIC is concerned about brokers and agents for the same reason we all are. They do provide valuable services to insured consumers. So they said, if there's anything HHS can think of to do here that we didn't, please do it. HHS couldn't think of anything to do that they couldn't because it read the rule, the statute exactly the same way that they did. There's no other way to read the statute, really. So the NAIC appointed this task force, executive level task force, to look further into the question because it was a question of great importance to them. The task force in turn asked the B Committee, the Health and Managed Care Committee, to look into it, and they asked the Health Actuarial Task Force to look into it, and they wrote a very comprehensive report, which I would really urge all of you to read. What that report found was—
But let me just for 1 minute.
Okay.
But when I read this letter, this letter makes me believe that the NAIC is supporting keeping this unambiguous rule, this MLR, as it is. That's what this letter says to me.
That letter is from, I believe that letter is from consumer representatives to the NAIC. We do not speak for the NAIC. We speak for consumers to the NAIC. Let me just finish.
But why, I mean, so you're agreeing with something that obviously it seems that the NAIC did not say?
The NAIC said in its initial finding that there is that the current law does not accommodate them. Anyway, there was this task force— I'll make this quick. This task force report found, number one, that although some places agents' commissions were being cut, other places there weren't, and number two, that in states that already had MLR rules, like the federal rule, consumers were not having a hard time finding agents and brokers. But it did come up with, I believe, 9 or 12 alternatives for Congress to consider changing the law if they wanted to reinstate agents and brokers' commissions. That then has been a subject of debate within the NAIC since that time, and just about 2 weeks ago, well, November 22nd, the NAIC plenary, all of the state insurance commissioners voted 26-20 with 5 abstentions, a very close vote for the NAIC, which usually operates by consensus and frankly a political vote, voted to recommend to Congress that something be done for agents and brokers, and that's basically what it says. So it's in your lap, but I would strongly urge you, for the sake of small businesses, don't drive insurance premiums up when they're just coming down right now.
Everything shows that insurance premiums are going up. I mean, even in my simple little southern, understanding of math, it seems that they're going up, especially since January of 2009. Thank you, Mr. Chairman. I yield back.
Thank you, Mr. West. Let me just raise one question, and Mr. Yost. So the thesis behind the MLR rule is that by, in effect, the regulating commissions and if you will, by virtue of having them in the cap, will benefit consumers. Isn't that the principle? That it will drive more benefit to consumers in terms of healthcare providers' services. Is that not correct?
The idea is that when consumers buy health insurance, they're looking for insurance for medical care, not for paying a lot for profits and bureaucracy.
Because I remember being a state legislator, again, going back in Colorado, where I remember being in a debate one time where the issue was about consumers, but from a trial lawyer point of view, in personal injury cases. And then and the question was, should we in fact regulate the fees that lawyers can charge as a percentage of the case in order that more benefit go to the victim? But I think that at the end of the day, the argument won out was that the victims could in fact shop around for lawyers and get one potentially with perhaps a lower contingency fee. How do you separate those two?
I think brokers and agents ought to be paid exactly the way lawyers and accountants and real estate brokers and everybody else is paid. They ought to negotiate a fee with their client, and that should be their fee. The MLR then should be raised. Administrative costs should be reduced to recognize the fact that insurers are not now paying for that. But if somebody wants to pay a broker 20% of their premium, I think they should have that freedom. But I don't think Congress should tell.
So what should be the cap then for trial lawyers in terms of their contingency fee? What cap should we impose on them? So that we protect consumers, so that we protect the victims that they're representing. What cap should be imposed?
That's not something I was prepared to testify.
Oh, but
today.
Surely you've thought of that. You're a law school professor. Please.
If you want me to talk about that, I can talk about that.
I would love to know, what is it 20%? Would 20% be a fair number?
I can't say. I'd have to look at that more closely. Okay. I mean, the problem obviously is that that lawyers who
Can you get back to me as to what a fair percentage would be? And so you've had time to deliberate that. Because obviously what we want to do, I mean, if we're going to regulate everything, because we don't believe in freedom, because we don't believe that free market competition, which unfortunately we don't have today in the insurance industry because of regulation, that we ought to look in terms of, to follow this logic through to the plaintiff's bar and to say there ought to be a cap on contingencies so that the bulk of the money goes to the victim.
I don't have a problem with that, and those laws exist in many states, but I'm not an expert in that.
Well, why not have a federal
one? I think that is a problem that many states have addressed.
No, but shouldn't we? I mean, if we're regulating something that is truly interstate commerce, because we don't allow small businesses and individuals to purchase across state lines. So if obviously the Commerce Clause is so expansive to warrant the rule that we are discussing today, then why doesn't the Congress of the United States have a rule of affecting the plaintiff's bar in every state in the country?
I think under the Commerce Clause, Congress could definitely do that, and you would have to decide whether that is something that demands your attention. I think that Congress decided 2 years ago that insurance was. And in fact, since 1946, it's been clear that Congress has the right to regulate insurance. They, in fact, since 1974, have regulated 85% of health care benefits through ERISA, and now they are extending that a little bit.
Okay,
but I'm sorry, I'm not an expert on attorneys.
Mr. Schrader, any further comments?
No, thank you, Mr. Chairman. I think we've covered it pretty well, and the goal would be to find some way to take care of the insurance agents and yet keep the intent of reducing health care costs for Americans going forward.
Well, I want to thank you all so much for your testimony today. This subcommittee will continue to closely follow the implementation of the health care law. I asked unanimous consent that members have 5 legislative days to submit statements and supporting materials for the record. Any objection? Without objection, so ordered. This subcommittee is now adjourned.